Oh, we're live, Pete.
Yeah,
My fault.
we're live.
Technical difficulties. Let's get going. We're late. We're
You're
late
doing
for
great.
court.
I feel great. We're late for court. If you're watching this live, if you come in, please, we would very much love you to send us questions. You can ask questions wherever you're watching, Facebook, LinkedIn, or YouTube. Those will come right into us. We'd love to see your questions come in during the live show.
But we might object because, we're in court. That's what happens.
It's court day. That's right.
Yep.
Here we go. Welcome to How to Split a Toaster, a divorce podcast about saving your relationships from True Story FM. In court, they would bicker and feud, each claiming the other so rude. The judge rubbed his head and finally said, "I now pronounce both of you screwed."
Welcome to the show, everyone. I'm Seth Nelson, and as always, I'm here with my good friend Pete Wright. I am not even going to try to compete with that one this morning. This afternoon, this evening, whenever you might be listening. Well done, Pete. I think you're a poet and you didn't even know it.
I think we're still the jury's out, let's say.
My dad would teach me that. He would say, "You're a poet and you didn't even know it, but your feet sure showed it because they're Longfellows."
Wow, that's a lot.
Yes,
There's a lot to unpack there. We'll do that in our bonus episode, Poetry Today. Can we review before we dig into trial part 2? What did we talk about last week? Do you remember?
Yeah, so this is when you walk into court on day 2 and the judge says, "Are there any housekeeping issues?" That's how we start, housekeeping issues.
That's how we start. And then you gave me an anatomy of the courtroom. We learned our rights from our lefts from the perspective of the judge directions.
Mm-hmm.
And we talked about a lot of logistics, the housekeeping, the stuff you don't see on TV. But today we're digging into the momentum of litigation.
Yes.
Is that fair?
Yes.
Right. How would you like to start your experience as a litigator?
So this is not what happens on TV. And sometimes, and this has happened in courtrooms that I've been in, after the opening statements, right? So you're the petitioner, you go first, you give your opening, the respondent goes next, they give their opening, and then after that, the judge, if you're technically going by the rules, will look at me and say, "Mr. Nelson, your case in chief, call your first witness." I've literally had a judge say, off the record, after openings, counsel in chambers, and brought us into chambers and basically said to one side or the other, "Yeah, that's not happening today."
What do you mean that's not happening? What's not happening? The judge is just done with you?
The judge is saying, "Your argument is not going to fly. That dog don't hunt. That is not going to work."
Wow.
Not in this courtroom. Because
the judge can do that.
Yeah, because what happened in this case, and this is public record because we're in an open courtroom, it was a post-judgment case. And in Florida, the law is very clear that you have to have what's called a substantial change in circumstance that is material. Mm-hmm. And that's had to happen from the last order regarding a parenting plan. It was dealing with kid stuff. And in the opening, that was actually done by my law partner, Kristen Scully. She laid out to the court that the majority, if not everything they're talking about, are all items that happened prior to the last order. And if it's before, not after, now this is substantive law, but we're in court. That's where the law gets played out. It's not going to be admitted into evidence because it's not relevant because it's happened before.
Wow.
It's not a change. Okay. Counsel.
So each one of these orders that you're referring to becomes like the next starting point.
That's right. Think of it as wiping the slate clean, wiping the slate clean. And now you start from here. What, if anything, has changed? Okay. So went into chambers, and basically the judge said to the other side, "Yeah, that's not happening." And they advocated for their client. "Well, judge, we do have some things that happened afterwards, and we're asking for X, Y, and Z, and I won't get into specifics. And, I went back to my client and said, look, here's the thing. I believe the judge believes us that there is a substantial change in circumstance, so we should win. But I don't think that's necessarily he's going to rule. I think he's going to listen to the whole trial, and then he's going to find a reason to do a substantial change in circumstance. And I think he's going to find a reason to then give them part of what they want and give you what you want, because you've got some issues that I think he could find against you. Let's settle this case.
Okay.
And so we ultimately settled the case. And then it's like, well, now we got to deal with fees. And so and I tell my client, they're asking for X in fees. It's going to cost you Y number of dollars, which is less than X, for me to try the case today and potentially have an appeal and all this other stuff. And we literally settled that case, not on the courthouse steps, in the hall of the courtroom.
Wow.
Actually, some of it was settled in the courtroom because the judge left so we could discuss the settlement.
Yeah.
So when I say anything can happen in court, I mean anything can happen in court.
Yeah. And how, what sort of an irregularity is that when you say like, we're just going to do opening statements and then everything's going to be shot to hell because the judge is going to throw that kind of a wrench at us?
You have to always be prepared for that.
Okay.
So does that happen often? Absolutely not. But when you have a very good judge on the bench that's been doing this for a very long time and knows the law and hears it and looks at the other side and says, is what they just said true?
Mm-hmm.
Why is that court going to waste judicial economy of a full day trial when everybody agrees?
Right.
Right.
Okay.
So, and there's some people would say, well, why can't you deal with that earlier, before? There's a lot of reasons that I could go into, which would be 2 other parts of trial just on this one issue. So be ready for anything.
One of the points that we ended on last week was a question that I've had based on things that you've said to me in the past, which is it starts and ends with you, the client, never get your day in court. And I would love to start the process of what the trial is beyond opening statements with that premise.
Sure. So you do opening statements. Let's just back up.
Mm-hmm.
The client doesn't do the opening statement. The lawyer does.
Right.
I'm speaking on behalf of my client. That's not you talking. That's not your day in court. That's you listening to me have your day in court, right? It's my day. Now, Mr. Nelson, call your first witness. That client does not make the decision who I call first. That client does not make the decision who I call second. That client does not make the decisions what questions I ask. So think about this. You want your day in court, and you're
so far
on
by
the
what you've
stand.
asked, we're 0 for 3.
Right. Now
I'm
I'm going to put the client on the stand. You're on the stand, Pete. It's now your time to talk, right? And I'm a really bad lawyer.
Mm-hmm.
And I think you're just going to, like, you insist on me calling you. I'm telling you it's a bad idea. You are not going to be a good witness. And you say, I'm going to fire you if you don't call me as a witness. I said, okay, I'll call you.
Mm-hmm.
And here I go. You ready?
Sure.
Please state your name for the record, sir.
Pete.
Your Honor, no further questions.
Okay.
That is an extreme example for the podcast, for the toaster.
Yeah.
Right.
Yeah.
But I control the questions. And when I tell the judge I'm done, I'm done. And if that client goes, well, Judge, can I say something? No, sir. You weren't asked a question.
Speak when spoken to.
Answer the question.
Pretty much. Yeah.
Okay.
So that, I think that's a really interesting thing to think about strategy. And I think to put in the heads of our listeners who are thinking, wait a minute, I want to go to court and yell and scream. Like, it feels like I deserve to yell and scream. I was put through hell in this marriage and I want to get
and
it
in the legal
chest.
process, not
and
just
in the
the marriage.
Process. Right. And so what we want to reinforce is trial is not that place.
No. What happens at trial is you get asked questions and you have to answer the questions. Now, the other thing that happens is you have to sit there with a straight face and not respond and not react and not make faces and not blurt stuff out when the other people on the stand, when they're being asked questions, are lying about you, are
Ooh.
calling you names, are saying that you stole or hid money, are saying that you neglected, abused, did not show up for swim lessons, did not go to your kid's graduation from kindergarten, that you failed to show up for your time sharing, that you haven't paid back medical expenses, and on and on and on, and that you had an affair, and that you said bad things about mom in front of the children, that you always cook them mac and cheese and that's it for dinner and no vegetables, and you are an alcoholic and you show up drunk and you do cocaine, and you go on and on and on.
Sounds like a great setup.
There's no joke here.
I
That's
know,
what you have to
that's the
listen
joke.
to.
I
I
can't
know.
believe it.
I know. That's the point.
Yeah.
So, and I counsel my clients very clearly on how you dress in court, how you respond, how you sit there, how you don't do it, because the judge is watching everything. And when they're trying to make a case that you've got a short temper and you blurt shit out in court,
Right. Don't make that case for them.
yeah, they're like, Judge, Exhibit A.
Yeah.
Okay. So court is no fun. Also, we will be speaking English in court unless there's a foreign, someone who does not speak English, which then there'll be a translator, which really messes with the flow.
Mm-hmm.
But you will not understand what is happening, even though we are speaking English. So, Pete.
Yes.
How
You're
much
going to do that thing where you speak English, but words actually mean the opposite of what they mean.
Well, that is similar to what I was thinking.
Uh-huh.
But how much do you know about the rules of the game of rugby?
Oh, Seth, have we met? I'm have very soft hands.
Yes, exactly. That's my point.
Okay.
If you and I are watching a rugby game together,
Mm-hmm.
because you are not a rugby connoisseur, you did not play rugby growing up, you didn't play in college, you know there's a game called rugby.
Right? I thought it was my friend's dog.
Okay.
That's how far we are.
Well, that's not fetch. It's rugby.
Okay.
So when I watched the rugby game, because I played in college and then in my 20s, after college, I am going to see more, understand more than you do. Not because I'm smarter, though I am. Not because...
Ouch.
Dude, I gave you a pregnant pause.
Oh.
I gave you the pause to let you chime in that you were. I set that up for you, actually, and you didn't take it, so I took it. Okay. Not because I'm smarter, not because I have any special skills. I've just seen it and played it, and so I understand it.
Mm-hmm.
You haven't been in the courtroom to see it 1,000 times like I have, to understand the law and how it applies in rugby. What are the rules? How does it apply to it? The ref blows the whistle. There was a violation. Like, I understand all that in the courtroom. I understand it all in watching rugby. You would not, even though you're a very smart guy.
Thank you.
Okay. All right. See, we made up now.
Okay. I mean, a little bit. Okay.
So that's the other problem. And things happen very fast in court. Because remember, we only have so much time. So you got to get in and get out with your testimony and your questions. And while all this is happening, I'm going to ask a question. And let's say you're on the stand. It's your day. I'm asking you a question. and I say, and we're on direct examination, I call you as
Okay.
my witness, I'm asking, and I say, isn't it true that you paid $500 in child support in August? Objection leading. That's what the other side says.
Okay.
Okay. Well, I just asked you a question. And so now, objection leading, and I've taught you, if you hear the word objection, you stop talking.
Okay.
And the judge says sustained.
Okay.
And now what do you do?
I don't know, because sustained, I think, is one of those words that means the opposite of what I think it means.
Right. So if it means sustained, it means the judge agreed with their objection. I have to ask a new question.
Uh-huh.
But
And the alternative is overruled,
very
which
good.
means the judge did not agree with their question.
Which means you have to
and
answer the
I
question.
get to answer. So
You got it.
overruled is good, sustained is bad.
If I'm asking you questions, the
Yeah.
answer is yes.
Okay.
If I'm the one objecting,
The answer
I
is
want to hear
no.
the word sustained. Right? So it depends on what side of the coin you're on that, Pete.
At what point did they decide to make up words for these things rather than just good and bad? Like
Yeah.
it's
Yeah.
awful.
I
Okay.
think it was like 1236 is when they started doing that. Okay. Not sure. It might have been 37.
Okay. Fair.
Okay. So with that in mind, you're on the stand. You're nervous about your money, your kids making a good
Mhm.
impression. We're always nervous when we try to make a good impression. I mean, I get nervous every time I go home at night. I still want to make a good impression on my wife. Am I going to do it this time? Who knows? You know.
Oh, those nerves are
So
probably good for you.
yeah. So, but you're nervous. You're in court. You're worried about your kid. You're stressed.
Mhm.
Your heart rate is racing. Even though we've prepared you, it's something new,
Mhm.
right? And there's an objection. The judge says something, and you don't remember. It's sustained. Do I answer? Do I not answer? What do I do? And sometimes they blurt out the answer, and then the judge goes, "No, don't answer." And you're like, "Oh, I'm sorry." So here's the rule: the only time you're ever allowed to ask a question in court is when there's an objection and the judge rules and you're not sure. And you can look at the judge and say, I'm sorry. Am I supposed to answer? Right?
Okay.
Okay.
Right.
Right. Or you sit there quietly, and your lawyer should do a good job. If you sit there quietly because you're not sure, your lawyer will ask either a new question or will say, you may answer the question.
Okay.
Okay. So look for those cues. All right.
Okay.
And the lawyer's not being deceitful or trying to like wink, wink, nudge, nudge, kick you under the table, answer this way. It's just the process.
Yeah. Well,
Stressful.
It's stressful. And it gets to my next question, which is, if I'm sitting there next to you and I'm hearing you speak in code about my case, the thing that I'm going to be thinking about and wondering is, are things going my way? Are we winning? Are we losing? How do we
Yes.
know? And I'd like to know from your perspective how you track that, like how you think about the momentum of a particular proceeding.
Oh, brilliant question.
Thank you.
Witness by witness, question by question. So I just had a trial. It was 2.5 days. At the end of day one, we came back flying high. We thought we did a great job. We thought that the opposing party did a poor job on the stand, like killed his credibility. We had an expert that said things that were favorable to us that we did not expect him to say. Okay.
Mhm.
We're like, this is going great. At the end of day two, when the expert was finished, the judge can ask questions anytime he or she wants.
Mhm.
The judge asked questions of the expert. And I was like, we're in trouble. Because
How do
when
you
the
know that?
judge is asking questions or having a dialogue, which might be, well, I'm trying to explain my question, and the
Mhm.
judge can do that. You get a sense of what the judge is thinking or what the judge is trying to get more answers to.
Mhm.
And those questions on what he was trying to get the answers to were not favorable to our case.
Okay.
Okay. And it was just, I'm not going to get into the facts of the case because the court
Fine.
hasn't ruled on this case yet, but we left there thinking this was great. Okay.
Yeah.
On day one, and on day two, we thought this is really bad. And so what people don't understand about a trial, especially if it's more than one day, what do you think I do after trial on day one before 9 a.m. on day two?
Well, I imagine you go home to your condo with young and vibrant aides, and you order pizza and drink Corona, just like Tom Cruise did in A Few Good Men, and plan for day two.
Yeah, and see, that's very good, Pete, because you can't handle the truth. Okay. The truth is none of that happens except for we plan for day two.
Okay.
And you have to adjust from day one. So
Okay.
it went
And
well.
strategy can wholly change between
Absolutely. Absolutely. We're not going to call this witness. We're running out of time. They're not going to help us.
Yeah.
We're going to call this witness, but pare it back. Oh, we had extra questions for this witness. We're going to ask those now because they didn't come out through the other witness. We thought that they might come out. And because the way that witness was handled, we decided it's best to get it through somebody else. Right. So there's all this strategy happening.
And you, if I'm your
approach
client,
this.
you've been prepping me all along. So I should not be surprised, though maybe disappointed or fearful, that you're pivoting between day one and two. That
That's
should
right.
not generally come as a surprise to me.
That's right. But day two did not go well, which means we had to pivot on day three. But also part of pivoting on day three for us in this case wasn't really a pivot. Okay. Is we were like gutted. And I said, you know what? This case starts tomorrow. And that's actually, I think, a line from that same movie. Right?
Yeah, that's pretty good.
Yeah.
Pretty good.
And because at that point in the trial, the judge had not heard from my client. And our client, in our view, was our star witness.
Yeah.
Okay. So the reason I go through that, and then at the end of day three, we felt great. Right. And we felt great based upon our client was an excellent witness, one of the best witnesses I had ever seen. And our my closing argument, I thought, changed the judge's mind. I think the judge might have ruled against us despite how well we did. But I thought the judge gave us another bite at the apple, or said, you know, I want to see written closing arguments.
Mm-hmm.
And I think I might have changed the judge's mind, not to rule in our favor, but not to rule against us that day.
Okay.
Okay. And now we have submitted, after the trial, the judge goes, go write what you believe the final judgment should be and cite to all the evidence.
Okay. That sounds like a law school assignment.
Yeah. And it's a 2.5-day transcript with hundreds of exhibits.
Yeah.
And you have to go through and say, this factor, look at this witness, what they said, what this witness said, what this witness contradicted himself, what this witness said. Did they contradict themselves? Look at exhibit number 57, page 4, paragraph 3, line 2. Boom.
Which is essentially what you did to build the case in the first place.
Yeah. But when you have to write it out after it's been tried and write a final judgment, it's because you have to cite to the transcript and to the page and the line of the transcript, which you don't have before because you don't know what page and line it's going to be or what people are necessarily going to say, despite you know what they should have said. Okay. Based on their previous depositions. So it's a lot of work. So we did that. The other side did theirs. And right now we're waiting for...
Sidebar, what am I doing as your client while you're taking 2.5 days to write this final judgment?
Oh, it took longer than 2.5 days. Well, depending on the client. Some clients will be like, just write it and then show it to me. Some clients want to read the transcript and be heavily involved and be like, you guys do your lawyer shit, but I just want to ask questions. Is this in and this in? If not, why? It's your final judgment, right? And you're allowed to do that. Okay. Sometimes we're like, hey, we're going through the transcript, but go through the transcript and I want you to jot down X, Y, and Z for us that you might know better, even though it's in the transcript. And Trust me, we're double checking and triple checking it.
Yeah.
Okay. So it depends on how involved you want to be. And so we've submitted all that to the court now, and we're waiting for the judge to make his final decision. And I can be absolutely wrong on everything I just tell you. Maybe we had a terrible day on day 1 and a great day on day 2 and an okay day on day 3. Like, my perception can be wrong. I don't think it is. And my law partner didn't think it was, and my client didn't think it was, but I haven't gotten a ruling yet. I don't know if we were successful, good lawyers on both sides, good arguments. You never know.
How long does it take for the judge, typically, given how busy they are, to get back to you after this amount of work has gone into preparing these arguments?
It could take a month or 2.
Okay.
Yeah.
So now I'm just be patient.
Waiting. Yeah. Terrible. It's horrible. Okay.
Okay.
So that just shows you, to your question about momentum.
Yes.
How does it change? And it changed by what the judge was asking at the end, or momentum changes because day 1, the witness said things we didn't expect that were in our favor and we felt great. But day 2, the same witness kind of changed their tune and the judge kind of picked up on that. And does that help or hurt? And was there an explanation for why it might have been nuanced a little different? So you're just flowing with it. And really what is the telltale sign is when the judge tells you what they're thinking at the time. I haven't made any rulings, but I'm a little confused by this. Or if the judge is asking questions, it's insight to what they're thinking. And whenever a judge asks a question of a client or of a witness, I think it's glorious. People hate it. I love it. I love it because it gives me an insight to what the judge is thinking. If he does that on day 1 or she does it on day 2, I can adjust for day 3. If the judge says nothing the whole trial and just makes the ruling at the end, case is over.
Yeah. Right.
So whenever a judge asks you a question, it's a positive thing. They're struggling with something and they're looking for an answer.
How much of your sort of witness to witness, moment to moment strategy is built on your relationship with the opposing counsel and the judge? I know we've had the judge on this show. We know that they're human beings. You have a unique relationship with all of them. How much are you trying to clock their sort of psychological state in order to make decisions on what to do next?
I always prepare for court the same way because I never know who my judge will be.
Okay.
And they're like, what do you mean? You're in front of this judge. It's set for trial. I'm like, yeah, you're right. Until that judge's child gets sick that morning and they call up and say, I got a trial to the chief judge. Can you get someone to cover for me? And a new judge walks in.
Mm-hmm.
And they'll say, well, I don't look like Judge Pete because I'm not.
Mm-hmm.
But I am Judge whatever, and I'm trying your case today. I've read the pleadings, I've read the motions, and Mr. Nelson, would you like to do opening statements? And off you go.
Yeah.
Off you go. So, yes. Will I be crafting my arguments based upon what I believe the law is? 100%. Will I be crafting it on what practicalities the law has on this case and the effects? Absolutely. Will I maybe weigh some of those more than the others depending on the case, depending on if I've been in front of this judge 20 times before and I know how they think about an issue? And ultimately, I've been in front of a judge where I knew exactly how he was going to rule because I was in front of him 4 other times on both sides of the issue, and he ruled the same way every single time, sometimes for me and sometimes against me, because he just picked, he was consistent, right? And I would have to say, Your Honor, my argument in this case is, and he's looking at me and I'm looking at him, and we all know what's about to go down, and my client knows what's about to go down.
Yeah.
Because I've told my client, right?
Right.
But this is a good faith argument, blah, 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 denied. Right. I mean, so yeah, you certainly are going to try to tailor it if you know how they feel about certain issues, not personally, professionally, by the
Sure.
law. This is what they think because you know that issue.
Right. If anything, you're prepared on arguments where you need to spend your time and where you probably don't because of
That's right.
you already know how that's going to turn out.
That's right. Great question.
Yesterday or last week, I should say, you
Yeah.
told us about opening statements. You're not arguing the law specifically in your
That's
opening
right.
statement. By the
That's
time you get to your closing statement, is it the same thing? Are you, or at this point, are you now deep in the trenches of the law and you're citing cases and you're doing your thing, or is it just the same as
We
opening
are
statement?
deep in the trenches of the law.
Okay.
Okay. And remember, whenever you are in court, there's you know this, Pete, and our listeners know this. You always have to think about your audience. You always have to think about your audience when you write a letter, when we're on the toaster, when you're talking to your kids and trying to get them to do something. They're your audience, right?
Mhm.
You deal with them differently than your boss, right? In court, the audience is the judge, but also the record, the cold, hard transcript. I'm
Mhm.
talking to the record. So, by way of example, in closing, instead of saying, Your Honor, we all know the factors, and here's why my client should win, and I ramble off a bunch of facts that I think the evidence showed. When you say in court, well, we all know the factors, the record doesn't know the factors. There's an
Right.
assumption there. So I have to say, Your Honor, pursuant to 61.13 subsection 3A, I believe the evidence showed blah, 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 blah.
Right. As long as, so at this point, you're referencing the factor.
I am referencing the factor
Yeah.
on the record, right? And so it's tedious because it's A through T.
Yeah.
So there are things that I will do at the beginning in my opening, which I will repeat in my closing.
Don't
Now,
even worry about it.
you will know this because I would have told you we've already prepared you for your testimony and we're going to go through the factors and we're not asking you any questions on these.
Yeah.
Why not? And I'm just making up the letters and now I'm making up the examples.
Sure.
Thankfully, Judge, there's no evidence and there's no domestic violence in this case. That's one of the factors. We will not be discussing it. The very next one is, did anyone lie or submit false evidence about domestic violence, which is also moot because there's no domestic violence. No evidence on that.
Okay.
Judge, the kid is 6 years old. There'll be no evidence that this child is of sufficient age and maturity to testify in court. Thankfully, Judge, I don't believe there's going to be any evidence that either one of these parties has mentioned this case to the child, and they both have shielded them from litigation. So there
There's
might
another
be two.
thing we don't have to talk about.
There might be two questions. Did you ever talk to your spouse about the child about this? No. Did she ever talk about it? No. Are you worried about this factor, sir? No. Ma'am, are you worried about this factor? No. We're done with that, Judge.
Okay.
Okay. So that's actually a good thing if you don't have to put on evidence for every factor, because one, it's less things for the judge to decide. There's less prep. There's less money you have to spend. And also you can focus on what's really important.
Yeah.
Deep dives are better than just like thin layers.
Mm-hmm.
Deep dives are better than thin layers, but don't go too deep and beat that dead horse, right?
Okay.
Mixing it, analogies there.
Yeah.
So closing, Judge, as I said in my opening, there was no issues on these factors, but here's what we saw on A. Here's what we saw on B. And Judge, I know they testified to X, Y, and Z facts under the factors A, B, and C, but under the law, you can't consider that.
Yeah.
Here's why. Here's the case. Refer to my memorandum of law that I've already prepared and submitted. Or something happens in trial and you got to know the law that you did not prep for the court because you didn't see it coming. And then on your feet in closing, Your Honor, as you're well aware, you can't do that because of X. And you know the law. You might not cite the case right away. You might not be Smith v. Jones 1992, right? But you know what it stands for. And it might be basic propositions of law that you're like, Judge, you got to think about this now, right?
Yeah.
So that's where you weave in the law and have that ready to go the best you can.
Trial ends. You end your 2.5 days, whatever it is. How do you measure success in the trial? How are you going to be communicating with me, knowing that we now have a wait ahead of us for the judge to?
If the judge didn't rule right away,
yeah,
right, and we're waiting and tells us to do the final judgment, so the judge goes, I'm going to take it under advisement, and in 2 weeks, I'm going to call you back, and I'm going to have a ruling hearing where no one's making argument. I'm just telling you what I'm ruling. Okay.
Yeah.
I'm going to just tell you, here's what went well. Here's the points we didn't do well in. I think that my witnesses, my clients I'm a tough grader. They're usually harder on themselves in grading how they did as a witness than I am on them because I've prepped them and prepared and, like, nope.
Yeah.
Like, did you answer the question that time or did you go beyond the question? Did you answer in the least number of words as possible? Right.
Yeah.
So
they generally know immediately what
they know.
what they've
not
done.
Only that, they will tell me afterwards. I was on the stand answering that question thinking Seth is not going to like this answer, but I just couldn't control myself. Like they're literally telling me that. And like, I'm like, shut the fuck up.
Yeah. That's all you had to do is you had one job. So there, we know that there's work that comes so that you get a ruling. What is the next thing that has to happen? Like you get a ruling. How do you finish the case?
So the judge rules in your favor. And the judge says, Mr. Nelson, I want you to prepare the proposed final judgment. And you draft it. You send it to the other lawyer. They disagree. You submit competing orders. And the judge, does their job and rules and writes it down. That's the amazing thing about our legal system. As flawed as it is, and there's a lot of flaws, if the judges are doing their job with the resources they have and the time that they have, there's a lot of caveats there. All the decisions are made right there on paper. They're not hidden.
Right.
Even the appellate, it's all made on paper. You get to read it. Sometimes it might just say denied without explanation, but that, for the most part, in these cases in Florida family law, there's a lot of factors, and the appellate court says you have to make findings, which means you have to tell me about the factors. It's all written there. Yeah. And the weaknesses of your case going in. And you know how to prepare for it. So for the client, losing sucks. But winning isn't that much better. And here's why. Here's why.
You should make that the tagline for the firm.
I know. Losing sucks, but winning isn't that much better. But here's why. In family law, it's not usually a win or a loss. You win some issues, you lose some issues. You don't win as big as on one, but you don't lose as bad on the other. And sometimes you lose them all. And it sucks. But then you get to tell yourself, I might have lost, but I was honest. I did everything I could. I'm not even saying the judge made the wrong decision. I understand why the judge made the decision because my lawyer told me this could be an outcome. So you understand it. But it could have gone either way. I was telling you, we got an uphill battle here. We got a shot, but it's not a good one. So understanding why the judge ruled, to me, at some levels, is so important. And where I get frustrated is when a judge makes a mistake and just out of left field. And I don't particularly, even if I win for a client in quotes, air quotes on win, and I don't know why the judge did it, like doesn't explain it, I'm like, okay, like my client's happy, but from my personal satisfaction and being a lawyer and wanting to understand and learn and always improve, that's hard to swallow. It's really hard to swallow when you lose and it comes out of left field. Okay.
Yeah.
I'm going to tell you something else about this, which is really interesting. Because people say, well, come on, Seth, you're competitive. You want to win. I'm like, okay, I want to win. Let's say that. I'm going to court. I'm going to advocate for my client. Yes, but I'd like to win. So how do I define winning as a lawyer? It's very simple. Does the ruling that we get beat the last offer they gave me?
Okay.
If we beat the offer, we won. Right? If we got the same offer, well, that was a big fucking waste of time. Okay. Which I'm saying facetiously because people want to go for it, right? If I'm just talking outcomes, though, like forget about the expense and the time and the stress.
Because we're going to court to try to beat the offer. That's the goal, right?
That's the goal.
If we liked the offer, we wouldn't go to court. Okay.
That's right.
That's so the table for me.
Keep it in mind and that's why I tell people, especially the other side, make my job hard. If I have if there's a pie and we're dividing it up and my best day in court is half, why don't you offer me 42%?
Okay.
Because right now you're offering me 0. My worst day in court is 0. Why would I not try to do better?
Yeah.
If my best day in court is 50-50, if I can get from 0 to 50, offer me 35.
Yeah.
Now, then I have to tell my client.
Get the game going, right? Get the conversation going.
Well, even if you say 35, take it or leave it, now I have to tell my client, look, I actually think 35 is a potential outcome in court. It might be on the low end, but it's a potential outcome.
In the range.
And the other high end is only another 15%, right?
Yeah.
I'm at 50 now. Do we really want to go fight for that? I think we earned it. I think you deserve it. I think the court should rule in our favor. But there's a 20% chance we only get this 35% of the pie.
Yeah.
Do we want to risk it and spend the money in all? So that's the analysis. But when you come in and tell me 0, okay, let's go. Tee it up.
We're going to court.
Right. But what happens is maybe on one issue, I'm like, yeah, you're offering me something that I think is actually worse than my worst day in court. So the lawyers don't always agree where the worst and best days are. So I'm going to go to court on that. But what happens if they're offering me that, but something else, they're offering me something better than my best day in court on another issue in the case? My client's got a decision to make. Maybe they're like, I don't care about that, what they're offering me. I care about where they're saying 0.
Yeah.
So that's one way to look at it. Now, here's another way. And that's how I always look at it. And I had a case once where, and I really don't care about this stuff. And a friend of mine said, man, there's this lawyer that is going around town saying how she really crushed you in court. And I said, really? And I was in the same courtroom and I heard the same ruling. And I said, okay, I'll bite. What'd she say? Said, yeah, Seth only got, 30% of what he was asking for. And I was like, I actually agree with that. And the guy, my friend was like, so she crushed you. You only got 30%. I said, no. First off, I should have only gotten 10%. I beat the last offer they gave me and I got more than I expected to.
Perspective is everything, right?
Right. But I know I'm now talking in terms of wins and losses. But that's not what we really do. And what I counsel my younger partners and lawyers and associates, how I gauge whether we've won or lost has nothing to do with the outcome on what the judge did. I lay my head on the pillow at night saying, did I do my best work?
Yeah.
And if I've done my best work and the judge ruled against us, fine. But I'm my harsh critic on myself, and I think that's why we improve. And that's what you want, I think, out of lawyers. Like, don't tell me about a win. Tell me about a loss and how you handled it.
Yeah.
What did you learn from your last trial? What mistake did you make? Because if there's one other lawyer telling you that they walk out of that courtroom not thinking, I should have said that. I should have objected here. I should have let that slide. I should have made a different closing. I could have tweaked my opening. If your lawyer is not that self-critical, find a different lawyer.
Find a different lawyer. Question.
Yeah.
We're at this point because the couple couldn't come to terms in mediation or earlier. So is there a mindset you take if you feel you're losing, knowing everything they went through and said and heard in the mediation? Do you prep your client for that? Is there something you say, like, if you hear the judge say this, it's probably over for us? Or as their lawyer, do you maintain positivity?
Oh, I am brutally honest.
Okay.
Will I be positive? Yeah, there's always good stuff that happens, but if it's bad stuff, I am not gonna blow smoke up your ass. I am not gonna make you think it's all roses and rainbows.
Sure.
No, it's my job to tell you whether I think it's going poorly or well and not, and how it plays in. Okay. At the end, the telltale sign, if the judge is going to say, okay, I'm going to make my ruling and I want you guys to do proposed final judgments, or maybe it's just a hearing, not just a trial. And they say, Mr. Nelson, I want you to prepare the order. You know, the work goes to the victor. That's a good sign. But let me tell you, I had a case where the judge goes, Mr. Nelson, I want you to prepare the order. And then the judge started saying the order and I was losing. And the judge got to the end and I said, Your Honor, let me be clear. You just asked me to draft the proposed order and you ruled against my positions on every one. I think my obviously learned counsel should be drafting that order. You're making me do the work. Like, you know, I mean, come on.
Yeah, if you lose on almost every decision, you've earned a pass on the work. Yeah. That's kind of the thought.
And quite frankly, you don't want me writing the order, because if I write a sloppy order, and the other side agrees to it, and the judge is busy and signs off, okay,
it's gonna you're giving them excuses to come back to court.
I've just set up an appeal for my client because I lost and I wrote a bad order. Now, I don't do that purposely. I take what the judge said and but sometimes they say stuff and you're like, well, what did you mean later?
Yeah. And
you don't have like, you do the best you can and the judge is going to review it. I'm not trying to trick anyone here. It's on paper, right? So that's a telltale sign. Usually, always exception, damn lawyers. Now, the other thing, sometimes judges will tell you, I haven't made any rulings yet, but here's what I don't really understand. Like, okay, how the judge reacts. The judge is human too.
Right.
You'll be looking and the judge will be like, all right, let's move it along. Got it. Yeah, Ms. Nelson, I got that point. Or the other side, I got that point. Or, yeah, I mean, I've been in court making legal arguments where the judge goes, Mr. Nelson, that dog don't hunt. Like, that you know to move on. Right, which is fine. Why are you going to waste your time if that's the loser? Keep going. So it's a really, really great question. But the bottom line is no, honesty with your client.
Okay.
Right.
This has been great. We've got our little two-part here on trial. This I think. Have we covered trial? Is there more we need to talk about, or are we putting a button on this?
Yeah, I think that we got one more show about this.
Oh no!
It might not be
Andy's going to be so mad.
Full 40 minutes.
Okay.
But I really think what we need to cover is how we handle ourselves in the courtroom and what you can do as a client during the day to help your lawyer in the case.
Okay.
So that's what we're gonna work on. So
there we go. That'll be trial 3 coming soon to a podcast very near you. Thank you, Seth. Thank you very much. Thank you, everybody, for joining us, for asking questions. Don't forget, head over to howtosplitatoaster.com. Click the submit a question button. We'd love to hear your questions. We'll answer them on the show in just a couple of weeks. We've got our next listener questions episode coming for you. So get those questions in now. We'll answer them very, very soon. On behalf of Seth Nelson, America's favorite divorce attorney, I'm Pete Wright, and we'll see you next time right here on How to Split a Toaster, a divorce podcast about saving your relationships.
Great questions, Pete.